Welcome everybody. Thanks for being here with us this afternoon. I'm Katie Earle. I coordinate this program, and we're joined here today with Valerie Stanek. Welcome, Valerie.
Thank you. Thank you for having me.
Always a pleasure to have you back. We appreciate you. And we have a lot of new folks on here today, so we'll quickly go through our housekeeping. And if you already know what you're doing, you can tune me out for the next 15 seconds. So we are recording this session, and I'll try to post it on our website in the near future. If you have any questions or comments for Valerie today, she goes through her presentation, feel free to type those in our Q&A panel. If you're on a computer, that's located likely at the lower right-hand side of your screen. Click on that, expand it, you'll see the text box, send your questions to me. And then if you're on a tablet, touch your screen, that brings up your control panel. You'll see a circle that has 3 dots, then you'll see Q&A. So same for you. So you'll see that text box and send your questions right to me. And sorry, my computer's going crazy telling me I should be running this class, which I am. All right. So quick, just want to thank our sponsors, which is my Department of Senior Services, Blue Cross Blue Shield of Western New York, Excelsior Orthopedics, and Wegmans. For all of their support and senior services is 858-8526 if you ever need anything. All right, now for the reason why we're all here. Valerie Stanek is an attorney practicing in the area of wills, trusts, estates, and elder law. In addition to practicing law, Valerie is a certified financial planning professional focusing on investments, retirement, and estate and long-term care planning. She lives with her husband and her Morkie, Alfie, in their emptied nest in Amherst, New York. She's here now. Valerie, take it away. Thank you.
All right. Thank you, Katie. Good afternoon, everyone. I almost said good morning. This presentation is all about trusts, which has a tendency to be either intimidating or very dry or a combination of both. I will try very hard not to make it either one. I'm going to try to simplify it and make it a little more accessible for everyone. Trusts are always a topic that comes up with attorneys in the context of being extremely expensive and complicated, and a lot of people have no idea whether it would be a useful thing for them to do. If you ask most people, they will not be able to really give you a definition of what a trust is or what it does. I'm hoping by the end of this conversation, you'll be able to identify, to be able to define what a trust is, and maybe have an inkling of whether or not it might make sense for you. So there are, like everything else in the law, the answer to whether or not you should apply this particular tool to your personal situation is a very frustrating one. It's one we use all the time as lawyers. The answer is always, it depends. So it always depends on your personal situation. And therefore, often the best thing to do is to have someone take a look and see whether it might make sense for you. Having said that, I am available to do a free consultation to take a look at your situation if you'd like me to. It's something that I do as a courtesy to the people who attend these seminars, and you're welcome to use the phone number or email address at the end of this presentation to contact me and ask me questions or request a consultation either by phone or in person for me to answer your questions and look at your particular situation. So the questions we're going to address in this presentation begin with, what is a trust? So a definition of really what a trust is and what it's intended for. The second question is, what can trusts do? What are the positive? What are the things that trusts can accomplish for you? And what of your objectives might they address? We'll talk a little bit about the different kinds of trusts, but I promise I will not get into grats and gruts and grantor trusts and all of those things, as attorneys really like to do, but I'm going to avoid that for you to keep you from falling asleep during the presentation. We'll also talk about examples of problems that we can solve using a trust. And then finally, we will talk about the cons. What are the costs and what are the potential downsides of having a trust? As Katie said, if you want to share your questions with us, please feel free to do that. And at the end of the presentation, I'll be happy to answer questions. So let's start with what is a trust. First of all, a trust is a separate entity. The whole purpose of a trust is to change the ownership of something from your name into the name of a separate entity. So it's a lot like setting up a business of some sort of like setting up an LLC or setting up a corporation, although by comparison, it is simpler for the most part. Um, a trust has its own tax rules. So depending on how you set up the trust might have to file a tax return or it might not. You can set up a trust so that any of the income that the assets that are owned by the trust pays out will be paid under your own income tax return. So you wouldn't need to do another tax return. Trusts have a life of their own. They live beyond you. So if any human being who is interested in the trust in some way, for example, you, the grantor, or the trustee, or any of the beneficiaries, if any of those individuals pass away, that doesn't mean that the trust dies. The trust continues on. And that's a very important feature as we will get into further when we talk about what trust can do. A trustee is the person who is the CEO, if you will, of the trust. If the trust is a company, then the trustee is the CEO. The trustee is responsible for keeping track of and managing the assets in a trust. Now, having said that, if you are the person who is setting up a trust and you are not the trustee, because in some situations you cannot be the trustee of a trust that you set up, depending, of course, on what you want to accomplish using the trust, your trustee will be responsible for signing off on any decisions that are made about what the investments are in the trust, what other assets like real estate the trust owns, whether the real estate or the investment should be sold, all of those things the trustee needs to sign off. Now, having said that, very often people will name someone that will work closely with them so that even though they're not the ones with the legal authority, they are actually in the background sort of guiding and helping to make decisions in regards to the trust. Trusts allow for very specific instructions. So as opposed to naming a beneficiary, let's say you have an IRA and you name a beneficiary, you say, I want my spouse to be my beneficiary. That's all well and good, and that will work. But at your passing, the assets that were in your IRA will go directly to your spouse in a lump sum. Now, if you happen to have a spouse like mine, for example, who isn't exactly a whiz when it comes to managing investments, making investment choices, and purchasing stocks or funds, isn't real good with taxes. I mean, that's all of that is you might imagine someone like myself would be the person in the marriage who would do those things. Well, that's absolutely true. So my husband might benefit from being the beneficiary of trust, where I can give very specific instructions to the trustee to help my husband manage assets. If my husband were also a spendthrift and were, liable to take the money and, buy himself a Lamborghini at the drop of a hat, I might also have in my specific instructions that my trustee is going to take my money, my IRA, my life insurance, or whatever the assets might be, put them in the trust and dole them out to my husband over his lifetime or over a 10-year period of time or whatever I might want to have happen, rather than give it to him in a lump sum. A lot of people do that for their spouses. Even more people do it for their children. So if you have a child, let's say you have two children, and one is very, very good with money, and the other one is not very good with money, you can leave the assets in a lump sum to your child who is good with money, but you can give very specific instructions to a trustee to handle the other child's share over that child's lifetime, or to pay to that child over a 5-year period of time, or to pay to that child at age, say, 30, 35, and 40. I mean, you can give instructions as specific as you'd like and as detailed as you'd like in a trust. Lawyers refer to that as dead hand control. If you're used to giving gifts to family members or giving financial support to family members periodically right now, and you would like for that to continue after you're gone, you want that control even after you're no longer with us. That kind of control is referred to dead hand control, and that's a very big part of what trusts are designed to do. Another thing that a trust can do is it can impose conditions. So in other words, my husband gets to receive X number of dollars every year, provided that the trustee has no information indicating that he might be gambling, for example, or on the condition that he continues to pay for health insurance for my children. I'm just making things up, but you see what I'm saying there. That kind of you can place conditions on the beneficiary by using a trust. So what are the objectives that you might have that a trust can accomplish for you? What are they used for in terms of what kind of tool they are? First of all, one of the things that people really, really want to accomplish when they set up a trust is to avoid probate. Now, why would you want to avoid probate? First of all, I'm going to step back 1 second and say, what the heck is probate? Most people know that assets, quote unquote, go through probate when someone dies. What that actually means is that you go before the court, whether you have a will or not, and any assets that have not been bequeathed to your heirs by the use of a beneficiary designation. For example, your IRAs, your life insurance, other things that go to through a joint account, for example, can go directly to your heirs when you die. Anything else that doesn't have a beneficiary on it has to go through probate one way or another, assuming that your estate is of a certain size, a fairly small size, frankly. So most assets go through probate. Houses that don't have some type of joint ownership or beneficiary arrangement go through probate. Why would we want to avoid probate? Well, probate can be very, very complicated. If you have, for example, if you have no children and your beneficiaries are a whole lot of nieces and nephews, and we're talking maybe 10, 12 people, maybe 15 people, maybe more. What your executor of your will or your administrator of your estate has to do in order to go through probate is to get all 15 of those people to sign off and to say, yes, it's okay if we probate this estate. In addition, your executor or your administrator has to pay more or less of a fee to surrogate's court. They have to make your will fairly public. In other words, all of those 15 people who are your beneficiaries have to see a copy of your will. And if one person throws a wrench in the works, they have to be called before the court, and they have to explain why they object to the way that your estate is going to be distributed. So there's a whole potential involvement of the court and approval of the court and court expenses, and not for nothing, also lawyers' fees that are associated with going through probate. There's also a significant delay before your assets can be distributed. Once probate court approves your estate and opens your estate, it approves your administrator or executor, there's a 7-month waiting period before they can distribute the estate assets. So there's a delay, there are expenses, there's a lack of privacy, and there's the potential for someone to object. And again, if someone objects, then everything has to go before the court, and it becomes complicated. So what does a trust do? It avoids probate. Your trustee becomes the boss. The surrogate's court does not get involved. There are no delays. There's no probate court costs, and nobody has to be informed. It is a private matter. You have now set up your assets in a private entity that probate court does not need to get involved in. What else can a trust do? A trust can postpone your gift or stretch out your gift. If you give something to someone in a will, or if you make someone the beneficiary of your IRA, they're going to receive that at the moment of your passing, assuming that they're not a minor. But even if they are a minor, that asset is going to be held on to until the minor reaches age of majority in New York, and then they're going to receive that gift at a time when they're pretty likely to go buy a Ferrari. They'll receive that gift in a lump sum at that time from an IRA or from a will. With a trust, what you can do is say, no, I don't want them to receive it at age of majority. I don't want them to receive the first portion of their inheritance until they're 25. I don't want them to receive the second portion until they're 28. They can receive the rest of it when they're age 29, 30, 31, whatever the age is that you would prefer. So you can postpone or stretch out the gifting. For some people, what that means is, especially where there's a significant estate, you can stretch out the gifting for the rest of the beneficiary's lifetime. So you can make it a lifetime gift. And you can tell the trustee that under certain circumstances, and you can define the circumstances, I want you to go ahead and take out extra in that year. For example, you can say to your trustee, I want my daughter to receive her share of my estate over her lifetime. So in equal shares over the course of the rest of her life. And if she buys a house, I want her to receive a lump sum of 20% of the value of the house extra in that year for a down payment on the house. So you have, again, a lot of dead hand control, and you can stretch out the gifting process. What else can a trust do? A trust can provide professional asset management for the beneficiaries. This one would be very important for my husband. He definitely would not be comfortable or interested, frankly, in, he's very, very good at other things, just so you know, but managing investments is not one of them. So the trust would name in advance a person, the trustee, who is responsible for managing the assets and making sure that they're invested properly. It also makes the trustee financially responsible. It makes the trustee a fiduciary who responsible for handling the assets in a prudent way. As I mentioned earlier when I was talking about avoiding probate, a trust also helps protect your privacy because your will is not open to all of your potential heirs. Because not only your heirs receive a copy, let's say for argument's sake, you have 6 children and you want to disinherit one of them because of whatever personal reasons that you might have. One of the reasons might even be, and I see this a lot, that you've already gifted that child his or her inheritance in advance. So you've already given them what you intend to give them, but the rest of your children haven't received anything. So they're the heirs in your will. Unfortunately, what happens is that all of the children will receive, including the one who is disinherited, will receive a copy of the will. And you may or may not want that to be so public. Especially if you have disinherited one of the children because you're angry with them, or because they're living their life in such a way that you don't approve. They're addicted to drugs or whatever the case may be. So you may not want to show all of the potential heirs a copy of your will. You want to just show your specific heirs and they don't even get to see a copy of the trust if they're beneficiaries of the trust. What they get to see is the portion that applies to them. So it's much more private and much more restricted into who gets to know what. As I said earlier, also you can place conditions on your beneficiaries, and I think I clarified that, but I'll touch on it very briefly here. My child can receive his or her first installment on their share of the trust to be paid to their school of higher learning, but only if they go to college. If they go to college, they get the money to pay for college. If they don't go to college, they have to wait till they're 30 to get their first installment. So you place conditions, you provide an incentive for people to do things that you would like them to do. There are limits on the conditions that you can place. New York State doesn't allow, for example, you to say, I want my child to marry a person of such and such a faith. That condition is not allowed by New York State. So there are certain conditions that you can place, but there are some that you cannot. So you need to do that advisedly. If you are the fortunate person whose estate is going to be subject to estate taxes, so we're talking about someone who has more than $10 million, using trusts to plan your estate can reduce or eliminate estate taxes. Trusts can also protect your assets from the cost of nursing home care. So a trust is very often used to shelter your assets so that Medicaid pays for your nursing care instead of emptying out your pockets to pay for nursing care. It can protect assets from the creditors of your beneficiaries. I have clients whose children or their spouses have own businesses, and the businesses are going through maybe some rocky times or might go through some rocky times in the future. They might have some significant creditors. If a child inherits outright, that money now is available for the creditors to go after. If, on the other hand, they receive it in a trust, the trust says specifically that it is not available to a beneficiary's creditors. It protects the assets against financially irresponsible or inexperienced beneficiaries as well. Now, something for you to be aware of is that a trust, and I get this question a lot, a trust can be as simple or as complicated as it needs to be. There are some trusts that, believe it or not, are actually free of charge, and there are no charges to set them up. There are no charges for them to be managed. To give you an example, in a will, it is not unusual for you to say that you want your executor to hang on to a small amount of money for the benefit of a minor child until they reach age 21. That kind of trust, because as soon as you say, hold on to this for a period of time, it becomes a trust. That kind of trust has no cost associated with it, either for the trustee. The trustee doesn't need to be paid to do that, and the lawyer doesn't need to be paid to do that, to add that paragraph to your will. So trust can be anything from that simple all the way to tens of thousands of dollars and very complicated and many pages long. So what are the kinds of trusts? Just to give you an idea. Trusts come in Living versus testamentary. A living trust is a trust where there's money in it or assets in it, real estate in it, a business in it during your lifetime. A testamentary trust has nothing in it. It lives either inside your will or as a separate document from your will, and it remains empty until your death. And then the will pours assets into the trust. There's also revocable versus irrevocable. A revocable, and these are exactly what they sound like. A revocable trust is a trust where typically you are the trustee. You can set up the trust. It will accomplish some of the things that we've talked about, even though you can take it back. So you set up the trust, you put the money into it, and you continue to control it as the trustee. A revocable trust can be completely dissolved at any time. You can put assets into it, you can take assets out, and you completely have the freedom to say, you know what, I don't need this anymore. I'm going to revoke it, amend it, replace it with something new. So it's much more flexible. Having said that, a revocable trust also provides less protection. If I have my money in a revocable trust and I am the grantor, in other words, I'm the one who put the money in the trust, and I have the right to revoke that trust, that's not going to protect that money from my creditors. For example, if I have a large debt because I've been in the hospital, there were certain expenses that my health insurance didn't cover, and now I've racked up a lot of debt with the hospital, that the money in that trust is not protected. If I need to go into a nursing home and my money is in a revocable trust, or my real estate is in a revocable trust, it does not protect those assets for my heirs if I need to use Medicaid for my long-term care needs. So a revocable trust will accomplish some things, but there are some things that it will not accomplish. Now, an irrevocable trust is what it sounds like. It takes away your control. You are no longer solely in control. The trust usually gives you some control, and certainly when you write the trust, when an attorney like myself writes a trust for you, you write it the way that you intend for things to happen in that trust. And the trustee works for you and has to follow your instructions that are in the trust. However, what you can't do is suddenly one day just say, oh, never mind, and take the money out of the trust without anything further. Now, what some people think is that an irrevocable trust literally means irrevocable, but it does not. Although you can't alone go in and say, you know what, the money I put in that trust, I'm going to take it out. I'm going to cancel the trust. You can't do that by yourself. But with the cooperation of the trustee and any of your beneficiaries in the trust, you can actually revoke an irrevocable trust. So there is some flexibility there. You can also write the trust in such a way that certain assets in the trust can only be sold with your permission. One of those assets is real estate. You can say, this rental property or my personal residence that's in this trust can only be sold with the approval of the grantor, which is you, the person who sets up the trust. So irrevocable is a little less flexible, but it is also much more protective in terms of estate taxes, in terms of long-term care expenses, and in terms of creditors. There are also trusts. Now, those are, by the way, those categories, living versus testamentary, revocable versus irrevocable, are broad umbrella categories of kinds of trusts. Under that umbrella, there are very specific kinds of trusts. I'm just going to give you a few examples of ones that are very common. The first is a special needs trust. A special needs trust is designed to provide an entity that can hold money for someone who is receiving government benefits because they are disabled. So if someone can't have more than X amount of dollars in their name because they're receiving government benefits due to a disability, there's a specific kind of trust that can be set up so that there can be money for them to go on vacations, buy clothing, get a massage, go get their hair cut, whatever they would like to do with it, other than the basic fundamental needs of life. So housing, medical, and food are provided by government benefits, but the Special Needs Trust can provide everything else. The Special Needs Trust is a kind of living, typically, irrevocable trust. Another type of trust is called a charitable remainder trust. Charitable remainder trusts are set up so that you can put a bunch of money into the trust, receive a very significant, sometimes, tax deduction, and receive the income from the trust for the rest of your life. And when you pass away, the charity, whatever charity you've named, receives the remainder of what's in your trust. So there are specific defined circumstances under which you can take money out of the trust. You can take all of the income out of the trust, and the remainder of the money that's in the trust goes to a charity. You also get a deduction when you put the money into the trust. You can put the money into the trust over time also. So you can do a contribution to the charitable remainder trust every year to reduce your income taxes. And then you take income out of the trust to provide for your lifestyle. And then at your passing, the remainder goes to the charity. By the way, you can also set up a charitable remainder trust that benefits your children during your lifetime. So the income that comes out of the trust during your lifetime goes to someone else, goes to your children, goes to your grandchildren, goes to some other beneficiary. So you can have the income go to whomever during your lifetime, but at your passing, the rest goes to a charity. There's also a Medicaid trust. Medicaid trust is an irrevocable trust, a living irrevocable trust, inter vivos irrevocable trust, that is set up specifically to allow you to preserve some of your assets for your heirs against the possibility that some point in the future you're going to need some type of long-term care. There is a trust that's known as a disclaimer trust that is used. It's also irrevocable. It's used specifically to reduce, to minimize, or even eliminate estate taxes. And finally, there is my all-time favorite. These I throw into people's wills all the time. This is one of those trusts that doesn't cost anything. It's a pet care trust. It's a trust that says, typically, I would like so-and-so to take any pets that I have at the time of my death and take care of them if they can. If they can't, I would like for them to be sure that those pets are turned over to a reputable no-kill shelter, and I'm providing, say, $5,000 for either the person who's taking the pet or the no-kill shelter. Whoever has my pets gets the $5,000 in order to provide for my pet's care. It's it's a paragraph that is 3 or 4 sentences long in your will, and that would be an example of a testamentary revocable trust, and that lives inside your last will and testament. Those are just some examples. Again, there are as many trusts as there are stars in the sky, it seems. And if you had all day and you were sitting down to have a beer with a bunch of lawyers, we could talk about it for a long time, but I'm not going to do that to you because it's painful. So let's talk a little bit about some of the problems that that trusts solve. This is going to cover some of what I've already said, but it kind of gives it to you in an example format. So the problem, one child is stable in terms of their finances and their marital status, for example. The other child is unstable, either substance abuse, their financial status, or they're in a shaky marriage. As I said before, what you can do is leave half of your money to the stable child outright and the other half of your money in a trust to protect the assets and protect the child who may lose that money to their drug addiction, to their gambling addiction, to their spouse's business creditors, to their spouse in the case of a divorce. So that's the problem that would be solved by a trust. Another problem that might be solved by a trust. You have a combined estate, which is approaching the limit that can pass to heirs without estate taxes. So you're getting really close to having to pay estate taxes to your heirs, having to pay estate taxes on your estate. So you have a really good problem. The problem is that you've got too much money. Neither spouse really wants to relinquish control of the assets during their lifetime. So you use a trust that is a testamentary trust, comes into being at death to provide for a plan that takes care of that problem. That particular, I'm not going to go into the details of how that's set up because it's complicated, but you use two different trusts, and they are testamentary trusts. They are revocable during your lifetime and become irrevocable at your death, and they're referred to as a disclaimer trust. You have another problem. You have a child who is disabled. She's receiving benefits for medical care, housing, and food. You provide for her other needs and for products and services that enhance her life. Vacations, clothing, going out to eat, those kinds of things. Her life will decrease in quality without your support, and any money left to her would disqualify her from all of her benefits. So how do you take care of her and continue to provide some extra comfort and some quality of life when you're not around? A special needs trust accomplishes that goal. So let's talk about the cons. You always have to talk about the cons. There are costs associated with having a trust. The first cost is for drafting the trust. Now, again, there are a couple of kinds of trusts that are very straightforward that come free of charge in your will. I draft those quite frequently. It's just part of people's wills. However, most trusts are more complicated than that because they're designed to accomplish something more sophisticated than that, and that requires being very careful not to run afoul of the rules and regulations. So there is a cost to drafting a trust. In my case, the cost usually runs somewhere between $1,500 and $5,000. That isn't true for all attorneys. That's just my range, okay? Other attorneys, and again, it could go north of there, assuming that the trust was extremely complicated and involved business succession and very large estates or very complicated drafting. There are also trustee fees. Now, trustee fees can either be eliminated or minimized by using someone in your family as the trustee. That may or may not be appropriate for you. There may or may not be someone in your family, one of the beneficiaries even, who is appropriate to be the trustee. But if you're fortunate enough to have a child, for example, as I do, who is very savvy with financial matters, and who can be trusted to be the trustee, then there are minimal, if any, trustee fees. In fact, in my case, I would specify in my trust and have that my trustee may not pay herself because she is also a beneficiary of the trust. If, on the other hand, your trustee is a professional trustee, if your trustee is a bank, or your trustee is a financial institution, or your trustee is a lawyer, there may be some trustee fees associated. For example, financial institutions who are trustees, like banks, often charge you a percent of the assets that they're holding for the trust as the trustee fee. So if they're holding $1 million, they might be charging 1%. 1% of $1 million is not trivial. So that a percentage can often be painful. Attorneys, on the other hand, not all attorneys, some of them charge a percent, and others charge by the hour. For a lot of trust, depending on the kind of trust that it is, there's really not very much work that needs to go in on an annual basis for that kind of trust. For example, if it's a grantor trust and I'm the trustee, the trust doesn't even need to file a tax return. So there are very few hours in the course of a year where where my services would even come into play. So you might be looking at anywhere from zero for some of my clients, all the way to maybe a couple $1,000s a year, depending on how complicated it is to be the trustee. There are also other financial institution fees, but the financial institution fees for a trust account should not be, and if they are, I would maybe look elsewhere. The financial institution fees shouldn't be any more than they are for assets that you're currently holding in your own name that are not owned by the trust. So if you're invested in a brokerage account or in a CD or whatever investment you might have, if you take that investment and put it in the trust, that should not change what the fees are that you've already been paying. It should be the same. So the financial institution fees, if you do it right, don't increase the cost of holding a trust. Some of the potential downside is irrevocable may actually mean irrevocable. As I said earlier, you can revoke an irrevocable trust. However, you do need to have your beneficiaries and your trustees sign off on that. So you need to be confident. If you think at some point you might revoke your trust, you need to be confident that your trustee and your beneficiaries will cooperate with you. Trusts can have tax consequences. They need to be done carefully so that tax consequences are eliminated, which they can be, or at the very least, that the tax consequences are minimized. Certain types of trust have their own tax schedule, and the tax rate for trusts is often greater than the tax rate for individuals. Trust can be unnecessarily complicated. My philosophy always is to either eliminate a trust if you don't really need it, or to use a trust in the most straightforward, simple, cost-effective way, so that you don't have a trust that requires a lot of complicated advice or complicated management down the road. So you can keep it. The goal is to keep it as simple as you can, while still achieving the results that you're looking for, achieving the objectives that you're looking for. And this is the point where, after I tell you how to contact me, you get to ask me questions. So as it says on this slide, you can call me or email me. I will set up a complimentary consultation. We can do that by phone, or we can do it in person. This is my contact information. For those of you who are on the phone, I'm going to read it out loud. My name again is Valerie Stanek, and my phone number is 716-913-0509. My email address is VSTANEK at ESQ, like lawyer, Esquire, right? ESQ CFP, which stands for Certified Financial Planner. So it's vstanek at esqcfp.com, not .co. That's a typo. So .com. And now, please feel free to ask questions.
Awesome. Thank you, Valerie. We
Pleasure.
do have quite a few questions here. Some you answered, some not yet, so let's go. The first one is, do laws governing trusts differ in different states?
Yes, they do. But for the most part, if you set up a trust that is set up in New York State under the laws of New York State, and the trust typically will say that it is governed by the laws of New York State, the trust is recognized in other states because of reciprocity between the states. So in other words, the states honor each other's trust laws. And your trust that is set up in New York State, if you move to Florida, for example, the trust is still valid. It doesn't need to be rewritten.
Awesome. Thanks for telling us that.
Mhm.
This next one, can you put an IRA in a trust?
You can, but it is not advisable for all kinds of reasons. Um, it Again, there are tax consequences. So when you make a withdrawal from certain kinds of trusts, you might end up paying higher tax rate. For another example, um, if the reason for creating a trust is to protect the asset from being used up in the event that you need nursing care, the IRA has some protections all by itself without without needing to go into a trust. It's also kind of paperwork wise, it's kind of awkward and complicated because IRAs are live under your social security number. A trust has its own social security number. So the IRS makes it complicated for you to do that.
Okay, good to know. Thank you. Next, we have a comment. This is a terrific talk, so informative. Thank you.
Thank you.
Next thing is, what happens if, for whatever reason, the trustee can no longer serve?
You almost always have a trustee a successor trustee that's named in the trust. It's not a bad idea to have as you can have, let's say, number one son or number one daughter named as the primary trustee, and then number two son or number two daughter named as the secondary or successor trustee, and then number three or number three successor can be named my law firm, for example, or whatever law firm that you're working with. The reason being that a law firm lives on beyond the death of the lawyer, or beyond the retirement of the lawyer even. So a lawyer always has a successor to their law firm. That's one of the things that we're not required to do, but most of us do, so that if we're no longer around, someone steps into our place. So it's a good idea to have sort of as your final person or entity on the list, an entity that isn't going to disappear like a human being can.
That makes a lot of sense. Thank you. Next, we have, do you think that down the road, New York State may change some of the rules regarding irrevocable trusts and protection for Medicaid?
Yes, I think not only can they, but they will. Those things definitely do change. Fortunately, what has happened so far is that trusts that have already, for example, trusts that have already been established keep the rules that they were written under. So, for example, when the look back period for Medicaid for Medicaid eligibility was 3 years. If I wrote a trust during that period of time, and then a year later, the government changed the rule to the 5-year look back, which is what it is now, they would have allowed the existing trust written under the 3-year rule to continue to be, for the 3-year rule to continue to apply. So most of those types of rules are grandfathered.
Okay, thank you, Valerie.
Mm-hmm.
All right, next one is, did you say that a third party special needs trust is revocable?
No, what I said is that it is irrevocable. Now,
Okay,
again, all of these things can actually be revoked, but what happens is that any protection that it provided is also revoked by revoking it.
that makes sense. Next we have, is there a way to provide for unexpected medical expenses like helicopter to Mayo or kidney transplant expenses in irrevocable trust?
Can you provide for medical? You can provide for medical expenses that the government health care, the Medicaid health care that you're receiving does not provide.
Okay.
So yes, you can supplement your health care with experimental treatments or with treatments that are not covered by your government provided health care.
Okay. Thank you for that. I'm just seeing a couple more things here. So anything else, folks, feel free to type it in now. We have someone who's wondering, can all siblings be co-trustees?
You really don't want that. A lot of financial institutions won't even allow you to have 2 co-trustees. Some of them will, but a lot of them don't like it because it requires both trustees to sign every single time you make a decision about anything. So I've actually had some financial institutions say they won't accept it. But if you have a bunch of co-trustees on a trust, that is, I imagine, I mean, I can write it that way for sure. I mean, there's nothing that prevents us from writing it that way. However, it is going to cause you problems with the financial institutions that you're working with.
Okay. Thanks, Valerie. This next one is, what happens to the contents in a trust if the beneficiary doesn't fulfill the requirements and or doesn't want the money or items?
That does happen sometimes. The money that's in the trust, then typically the trust is written so that if, for example, my child doesn't go to college and so they don't get their gift because they didn't go to college, they will get it later. Or if it says my child is going to get this money at age 25 and another 30% at age 30 and another 30% at age 35, if my child passes away before they get all the way to the last payment, whatever is left will go to another, the trust will be written in such a way that whatever is left will go to another beneficiary. So you always you always sort of make sure that even if the conditions of the trust are not met, or if the person who is the beneficiary doesn't survive, that there's that the trust assets are accounted for and flow where you want them to go after that.
Okay, thanks for that, Valerie. You
Yeah,
actually answered.
Yeah, we always anticipate that. Always anticipate that.
Yeah, you answered one of the questions that came through without even knowing it. So thank you.
Perfect.
I'm just seeing one more thing here, and it's when establishing a testamentary trust, are the transferred assets, if stocks, subject to capital gain tax, assuming the stock is increased in value over the cost basis?
No. What happens if it's a testamentary trust? The stocks won't be in that trust at the passing of the person who owned them when they die. They will be stepped up in basis at the moment of the person's death. So you may have purchased that stock for $10,000. At your death, it's now worth $100,000, and the basis becomes $100,000 at your death, and the money is poured into the stock shares are poured into the trust with a basis of $100,000.
Okay, thank you for explaining that.
Mm-hmm.
We'll just give it another second here to see. Oh, okay. Is cost basis step up also true for a trust?
It depends. You want to write the trust in such a way that you make sure that it is.
Okay.
And now there are certain types of trust that accomplish certain specific things where the step up in basis, especially if you're talking about estate taxes, right? Where the step up in basis is you lose the step up in basis, but you gain a bigger advantage of losing the estate tax. So when you have to choose between one evil and another, you always choose the lesser evil. So some trusts can be set up in such a way that you do lose the step up in basis. But for most of my clients, we write the trust in such a way that it preserves the step up in basis. That's a very important tax advantage. That, by the way, sometimes a lawyer is less focused on taxes than your financial planner would be, for example. So it can be very handy for your financial planner and your lawyer to be the same person, as I am. But it can also be very handy if that isn't the case. If you're very happy with your financial planner and your financial planner and your lawyer are not the same person, I would recommend that you have them talk to each other about things like taxes.
Thank you, Valerie. Well, I'm not seeing anything else, so we'll just give it a second here. But before we close, is there anything else you want us to know about trusts?
Uh, there's a whole, like I said, I could spend the entire rest of the week with you telling you more about trusts because I'm a trust geek. But there's no more for me to tell you about trust that isn't going to put you to sleep.
All right. Well, with that, I think we'll close while we're all hopefully awake. And Valerie, thank you for your time. And everyone who's on, thank you for being here. We appreciate you. Enjoy the rest of your day.
Thank you so much. You too.